You, I can't hear you.
How you all doing today? How are you all doing today? I am so excited to be here. Thank you so much for joining. Right now we have approximately 11 people on. Thank you so much for showing up today. You know, our topic today is just so vital and so very important. So I'm so excited to get into it. But anyone who knows who come to the Grand Rising Elizabeth Wealth Building Wednesday show, I love to start it off with a success story. Okay, so I just picked one out. A lot of you probably have heard this one before, but it's okay. So here we go. William Wrigley, the multi-billion business owner, like most business owners, had a rough start. He was born in Philadelphia, Pennsylvania. Young Wrigley didn't do well in school. He dropped out and ran away from home to sell soap door to door in New York. He came back after 2 years. He continued to sell soap door to door, working for his father's small business. At age 29, Wrigley moved from Philadelphia to Chicago with only $32 to his name. He used his money to form the Wrigley's Scoring Soap Company. His business made very little money, if any. William then decided to offer his customers baking powder as an incentive to buy his soap. The soap still didn't make any money, but he discovered the baking powder was more popular than his soap. Wrigley switched to selling baking powder to giving his customers 2 packages of chewing gum for each can of baking powder they purchased. Again, Wrigley found that the premium he offered was more popular than his base product. This caused William to concentrate on the manufacture and scale of chewing gum. After years and years of working and building his new chewing gum business, it was this new business that made William wealthy beyond his wildest dreams. William decided to purchase the Chicago Cubs baseball team, renaming the stadium Wrigley's Field. Today, the Wrigley's Corporation has products that are currently sold all over the world. Their brands include Big Red, Extra Cell, Excel Mist, Freedom, Spearmint Gum, Eclipse, Altoids, Lifesavers, and many more. They currently employ over 16,000 people and have revenue of over $5 billion a year. Through the Williams Foundation, millions of dollars are given each year to help the needy and disadvantaged all over the world. I declare and decree that everyone on this call is a success story. We are a success story. And what is so profound with this is that sometimes you have to be open. You got to be able to shift. He was able to see other opportunities because sometimes how you start out may not be how you end. You just got to stay in the game and just stay in the game. It will work itself out. So you got to be flexible. He was flexible. He paid attention to the trends. He paid attention to the customer needs. So you have to pay attention to your customer needs, what they really want. It's not based off of really what you want. What is your customers asking for? What is the demand? And you may just want to go ahead and just switch. So I love these success stories because it shows people don't know your story. They don't know your struggle behind your success. Okay, and so this is amongst other multi-million dollar stories that I shared. The same thing, they had a story. They could have gave up. They were poor. They didn't have their parents. Like, we can't make that our excuses. It doesn't matter how you was brought up. Just stay in the game. Be diligent. Have faith and stay in the game. Okay? So I'm excited about today's topic. It's been the topic all week, all month actually, on the Wealth Building Wednesday. For those who don't know me, my name is Lakeisha LeGrand, also known as Madam Finance, because I help everyday people build wealth with confidence. Because we all can do it. We all can do it. It's not hard. For a lot of us, it's just unfamiliar. Don't let the big things that's unfamiliar stop you for pressing on. So I'm so happy to have our guest Tina back in the house. By popular demand, some people missed it. It was like, oh, I hate I missed that show. So you know what? I said, Tina, we need to have you back because they keep talking about you, Tina. Thank you, Russ, Dr. Hoover, and Dr. Reed for showing up last week. Oh my God, y'all did the doggone thing like y'all always do. So I really appreciate that. So today we're talking about this important topic regarding trust and wills. Okay. And I had my god brother, called me up and talked about his father passed away. And he said, my father, he gave me my house. He gave me the house. So he's in there, he fixing it up. He doing all this, spending all this money. And when he called me saying he needs some help, I'm like, that's really not your house. It's really not your house. Because he didn't give it to you. You know what I mean? It ain't your name is not on the deed. It's going to go to probate court. Like it's going to go to probate court. And so I do have to call him because he's probably going to have to go to Monroe. I think it's 400 Monroe to go down there, have the death certificate, let him know that his father, has passed. He is the only child. So, most likely probably will get the house. But this just goes to show another real scenario that people go through every day, not setting themselves up properly. Like, a lot of us on this call are Henrys. What is a Henry? A Henry is a high earner, not rich yet. Okay? A lot of us are Henrys. We have, but we're not rich yet. But we're working on it. So we need to know ahead of time, what are we supposed to be doing as we building wealth for ourselves? As we have these startup businesses, as we're making money, we're making big moves, that we need to know what to do, how to set ourselves up properly. So I just wanted to go through this list that I have, okay, of people who did not take care of their estate planning. They didn't do a great job of their estate planning. So everybody probably heard of Jimi Hendrix. In 1970, he's the legendary guitarist who passed away without a will, resulting in a legal battle over his estate that lasted more than 30 years.
Wow.
30 years. We got Bob Marley, 1981. Despite battling cancer for 8 months, the iconic musician did not create a will. His $30 million estate had dozens of claimants, leading to prolonged disputes. People all the time, they become related and everything. You know what I'm saying? They be coming out of the woodwork. You ain't seen them forever, but they trying to get that money, honey. You got Howard Hughes. In 1976, the billionaire entrepreneur died without a valid will, leading to his $1.5 billion estate being divided among 22 cousins after numerous fake wills. Okay, surfaced and made the process go a lot longer. Extensive legal battles because he didn't have a will. You hear that? Fake will surfaced. Okay, Pablo Picasso, the renowned artist, died in state, leaving an estate valued at several $100 million. It took 6 years and an estate of 30 million in legal fees to settle his estate among his children and grandchildren. 30 million in legal fees.
Mm,
30 million.
mm.
Lakeisha, Lakeisha,
Yes.
close your video, dear. You got a low signal right now, and you're freezing up.
Okay.
So if you turn your camera off, it'll improve your bandwidth.
Okay. Prince, the musician, he had $156 million estate, was in limbo for 6 years due to the absence of a will, with over 45 individuals coming forward as potential heirs. Aretha Franklin, the Queen of Soul, died without a formal will, leaving an $80 million estate that resulted in legal disputes among her four sons and the IRS, which claimed she owed $7.8 million in taxes. Okay? We got Amy Winehouse. The British singer died in state at 27, leading to her 4.66 million estate being inherited by her parents, despite reports of her contentious relationship with her father. Barry White, the soulful singer, died without a will, resulting in his estranged wife, y'all, inheriting his entire estate, leaving his longtime girlfriend and 9 children without anything. How does that happen? Really? How does that happen? The last one, Sonny Bono. The magician and politician died in a skiing accident without a will, leading to claims against his estate from his widow, his ex-wife Cher, and an alleged love child. Okay, these are live, real scenarios that happen on a regular. I mean, the list is long. Okay. But look how things are happens. And if you owe taxes, if you owe money to other people, this stuff actually has an effect on making sure that your family have what they need. So with that being said, I want to give Tina the floor. Tina, a lot of people was not here when you were here, so please go ahead and introduce yourself, your credentials, and y'all, she gonna bring it again, I'm sure.
Thank you, Lakeisha. That's those are awesome stories, and there are more and more and more because there are less than, let's see, there's 75% of the United States population that do not have wills, believe it or not. So it's just not the rich, wealthy, high-profiled individuals. It's most Americans do not have a will. It's one of the worst things that they want to think about, right? Death and dying. So but I meet with people and get to explain the process to them, and they understand fully when I'm done. So my name is Tina DiPietrantonio. I am a member consultant for a legacy assurance plan. We are an estate planning service. We are not a law firm, and I am not an attorney. Although I've been known to practice law without a license in my past, I am still not a lawyer. So what I'm going to do is I'm going to share my screen with y'all, and just to but sharing is not turned on. Send request. Okay, I think you have to allow me to share the screen. Oh, did you hear anything I said? Was I muted?
No, we can hear you.
Okay, because it said my audio was muted. I need to share my screen, Lakeisha. Can you allow me to do? Okay, there it is. Thank you. So basically, I just want to speak to that one point about the $100 million estate costing $30 million. And this is because probate can cost anywhere from 3 to 8% of the total value of an estate. That's a lot of money, and it's actually a fact that does happen. So I'm going to show you how to be able to protect your assets from probate. That is the topic that most people are concerned with. So what I'm going to do is just start right off the bat with probate, because that, as I said, is the biggest concern. So let's see. So probate, I'm going to show you what probate is, how it can affect your family, and what choices you're going to have for creating an estate plan. Also, when people make plans, there are common estate plan mistakes that can be made, and a will does not protect you or your family from probate. How to maintain 100% control of your estate regardless of your incapacity or death, and how legacy assurance can help you do that. Can everybody hear me okay?
Yes.
Okay, good. I just want to make sure. I don't trust these Zoom calls. I think they all right, hold on. I got to go to the next page. So probate, what is probate? There are two types of probate. There's death probate and there's living probate. A lot of people don't know this, that even when you're alive, you may be required to go through probate. So death probate deals with how your assets are distributed after your death, and living probate deals with how you as a person are managed and how your assets are managed in the event of incapacity. And we all know that there's a certain amount of uncertainty in life, and incapacity can happen to any of us at any time. Go out for a skiing date and you could break your neck. There's just a walk out on the corner and get hit by a bus. It's there, it happens, and it happens fairly often that people become incapacitated and that they're not protected. So death probate basically comes from the word probatio, which means to prove. It's a process of proving, if you have a will in place, it's a process of proving that will is valid. But it's a government-controlled process because the probate judge is the one that controls it. And he'll help make sure your debts are paid and establish clear title to your property. Once everything goes through probate, then your assets are distributed. And it can be a very lengthy process. And it can be a very contentious process, quite honestly. So I'm going to show you a slide that's going to actually help you understand the process of probate a little bit better before we move on to living probate. So what happens when you go through probate and you have a last will and testament, or you don't have a last will and testament? If you die without a will, it's considered intestate. And in fact, you really do have a will, because your will is going to become the will of the estate, the will of the state of whatever state you live in, Michigan, for example. The judge will decide who, what, when, and where gets your assets. If your will does not come forward and expresses your desires, well, no one knows what you wanted to do, right? So somebody has to make that decision. So when you go through probate, you have to hire an attorney, pay them a retainer. Then the attorney goes in and petitions the court to open the estate. They publish notice of your death. The executor, if you had a will, files a bond. And then your assets are inventoried and appraised, which involves more fees and more services. Then the creditors are notified. And this is what Lakeisha was alluding to. They come out of the woodwork. And in fact, a lot of contractors deal on a cash basis. Believe it or not, they keep track of probates on houses, and people. You can look in the probate court and see whoever filed the probate. And they have actually been known to file false claims because it's cash transactions and nobody can prove that it wasn't paid in cash. If they have an invoice that the state cannot find a payment on, well, then that could be a valid claim against the state. So once all the creditors are notified, the judge makes sure that the debts, fees, and taxes are paid. And then ultimately, there's a petition to the court for distribution of the remaining assets, and then the assets are distributed. So how do you avoid this process of probate? I'm going to show you that after I talk about living probate. So living probate is the process whereby you become incapacitated and you did not have powers of attorney in place, right? So no one knows who you had selected to take care of you. And living probate has to be filed if you become incapacitated, either Alzheimer's, dementia, stroke, accident, heart attack, anything that renders you incapable of making your own decisions. So if you do not have durable powers of attorney in place, which is a big part of estate planning, you need to have powers of attorney for both financial and healthcare matters. Well, then guess what? the court's going to decide who is going to take care of you. They're going to decide who's going to manage your finances. And it might not even be anybody that you know. And that's the scary part, that there could be somebody possibly taking care of you that does not even is not even a part of your family. So guardianship is the person who's going to care for you, where you live, will manage your daily activities, eating, bathing, who'll make your medical decisions. And the conservator is the person who'll manage your assets, who'll balance the checkbook, pay your bills, ensure security of your household, maintain your property. And I personally am going through this process with my 90-year-old stepdad. I was fortunate enough to obtain a guardianship and conservatorship for him before the hospital realized that he was incapacitated mentally. I mean, he's with us some days, but other days he can't remember what he had for breakfast. So those are very important components of doing your estate plan. That's the thing that I worry about the most, because when I'm dead, let's face it, I'm dead, right? I'm not going to know what happens. So the overall cost we know what probate costs for your possessions. It can be anywhere from 3 to 8% of the total value of your estate. Living probate, however, is between $5,000 and $10,000. You have to go in, somebody has to open up an estate in your name, and the judge has the authority to decide who is appointed both guardian and conservator. And there are some movies out there that you might want to check. One of them is I Care a Lot. It's on Netflix. And it shows just how this process can go so terribly wrong. In this particular movie, there was a judge who was crooked. There was a nursing home that should not have been in operation. And then there was a court-appointed guardian that 3 of them were in on a scam. So an individual would come into the nursing home having no family and no viable will or anything in place. The nursing home would call the judge. The judge would appoint this woman who was the conservator, and she would then proceed to liquidate all of this person's assets, and they would divide the money amongst themselves. So it's really, it can be a very dangerous proposition to not have an estate plan in place, including a living estate as well. And, accountants have to be appointed. Conservators have to keep meticulous records if they go through probate. And this is where the ongoing legal fees and accounting fees. And of course, the loss of dignity is the worst, because I certainly wouldn't want anybody bathing me or feeding me if I didn't know who they were. I don't think I would enjoy it in any event, but especially if I didn't know who the person was. So basically, that's an important part of an estate planning, is powers of attorney. And what I'm going to talk to you about is how you can avoid this happening. And the one document that Legacy Assurance Plan really promotes is a revocable living trust. And that's because it's different than a last will and testament, because it completely avoids probate if it's properly drafted and properly funded. So having a living trust puts you in control, basically. Once you do your estate plan, you're going to know who is going to take care of you. You're going to know who is going to manage your assets. And having your trust in place, you know where your assets are going to go. You're the titled owner and you're the trustee owner, and you retain total control. So the living revocable trust basically is a document that holds title and ownership to your property. So any property that you own, homes, motorhomes, camps, high-end vehicles, or any vehicle for that matter that is worth a significant amount of money, if it is more than the threshold to meet probate in your state. And usually that's a small amount. If your assets exceed $25,000, it's generally susceptible to probate if you don't have a will. So with a trust, you're in control even if you are not living anymore, because you've already made all those decisions. And this diagram is a great example of how this happens. So all your assets on the left side, your house, your bank account, your personal possession, your vehicles, they all go into your trust. And it's called a funding process, whereby we retitle everything for you, that all your possessions will be in the name of your trust. For instance, Sharonda Taunt may have a trust. So her deed on her home would say Sharonda Taunt trustee of the Sharon Detente Revocable Trust. That's how it gets funded. Same thing when you go to the Motor Vehicle Bureau and you re-register your vehicles. You make sure they're in your trust, and that's by simply adding trustee after the name of after your last name. And generally, you have a certificate of your trust to present so that they know. So what happens once it's in your trust, you can see, you follow it down, it bypasses probate. There's no probate involved, and it goes straight to your beneficiaries. Likewise, your liquid accounts are generally distributed by beneficiary designation. So they can go directly to your beneficiaries immediately upon your death. So there's no wait, no delay, and leaves very little room for fraud. And as I said, trust allows you to completely privatize your estate. Therefore, you pay to have your trust and your estate documents done, and that's it. You don't pay another fee for the rest of your life through legacy, because we are there with you every step of the way. You become a member of Legacy Assurance Plan, and as a member, you have access to changing your documents. You have no attorney fees going forward, no court costs, no delay in distribution, no public record. In fact, people wouldn't even know that you have passed unless somebody files a death obituary in the paper. It minimizes stress, and it once again puts you and you alone in control. It's a fabulous vehicle to protect yourself. But as I said, it's not enough, because you have to make sure that things are put into your trust. And that's a common mistake that a lot of attorneys make. The American Bar Association came out with a study a couple of years ago that said that every single attorney in the United States is absolutely legally able to prepare an estate plan. However, less than 1% are actually qualified. There are all kinds of attorneys out there, and some of them, are sole practitioners, and they want to just not turn clients away. So they do bankruptcies, divorces, litigation, trust, it goes on and on. So we make sure that your trust is properly titled. We contact you yearly to make sure that there haven't been any changes that you are unsure of, and we make sure that your trust is always fully funded. We're there at to do possible updates with the death of a spouse, and we're there to help you or your family through the process in case of a life event that causes you to become incapacitated. We're also there at the end to help. Yes.
We have a question.
Sure.
A hand up.
Oh, okay, great. What is it?
Okay, so what about we have a lot of business owners here, and welcome everyone. What about if you had a business? Can your business be put in your trust? How would that be handled for those of us who, have a business?
Absolutely. LLCs, businesses. So what happens is we basically put the business in the trust by, we have special use documents, we call them. So what happens is the business becomes part of the trust by a renaming of, it's not by renaming, it's by actually listing it in the trust. And there are special documents that we file, but yeah, we do a lot of those businesses. We put LLCs. In fact, Legacy Assurance Plan has a business portion of their program whereby we can help you make sure that your documents, your business documents, are in good order, and then put them into your trust. We can start and create business documents for your business from scratch. So one instance I can think of is I had a member that owned several LLCs because he had properties that were put into the LLC. So what happens is he wanted those to be protected from probate, because even though they're in an LLC, they're still going to have to go through probate. We funded them into the trust. So that can be done, and it is done on a regular basis. It's not something that's an anomaly. It's actually happens all the time. Does that answer your question?
Yes. So okay. I have another. So what if, you're in the real estate, I love studying millionaires and billionaires, and a lot of them do have property into their portfolio. So what if you own one property and then you own another property, so you can keep putting these things in there? Are you saying it doesn't cost extra to update your?
that is a new situation. So what we do is we calculate the cost at the beginning. We go through a lengthy intake membership form. So we know what you have. We know what your business are. We know where your properties are all located. And we do that at that time. But 2 years down the road, and you need to put you want to create another LLC from scratch, then we can help you do that. And it is an extra cost. I think it's much cheaper than, I know I paid $2,500 to create my LLC. And I think that to create an LLC from start to finish, I haven't done that yet, but I know what the cost is. It's somewhere around $1,500. And that creates all your documents, all your, what do they call, articles of incorporation, or your articles of the trust, and then that gets put into the trust. At that time, you can call us, or when we call you at the end of the year to find out if anything's happened, then we would discuss that at that time. And yes, it is an extra cost, because your state plan basically involves, at the time that we do it, it includes a revocable trust, powers of attorney for both financial and medical, an advanced health care directive, retitling of your property, which means preparing new deeds for you. And then, see, deeds, I just lost my train of thought. I guess I haven't had enough coffee. I guess that is it. So there's an advanced healthcare directive, right? So there are about 6 different documents that are the good base. They're a strong, solid basis for an estate plan. But there are other things that we do. I'm just simply, within time constraints here, I'm just kind of giving you the basics. But yes, there isn't anything that we can't help you with when it comes to estate planning. We can put everything into your trust.
Okay, Queen has her hand up.
Hi, Queen. What's the question?
Tina, my question is, do you, like you talk about a trust, do you need different trusts for each one? Like when is there
No,
one trust over
one
everything,
trust.
or you need
Yes, I understand what you're asking. It's one trust. Now, there are different trusts, however, that you may, after speaking with the attorney, we have attorneys that we have vetted, and they're all part of your membership. So it's an attorney that is preparing your documents. So for instance, let's just say that you own a home and you own a camp, and that's great. You want to protect those from trust, but you also own 70 acres that abuts the back of your property that you want to keep in a wild state for use for the public or your family or whatever you want to do. That would require an irrevocable trust. And that's what irrevocable trusts are generally used for. And the difference is, as with a revocable trust, you are the owner and you control it. But an irrevocable trust, you're basically giving the property away to the trust. You do not own it any longer. You have to appoint a trustee, and the trustee will be the person in charge of taking care of that property. However, you are responsible for paying the bills on that property. So if there are taxes to be paid, you still have to pay those taxes. If there's a building on that property, you still have to maintain the insurance. However, you don't get any of the benefits of ownership. You don't get a tax deduction or anything like that, because essentially you've given it away. You also, a lot of people put family properties into an irrevocable trust. And the only caveat with that is you cannot have a mortgage on that property that you put into an irrevocable trust, because the bank won't allow you to give a property away that you've signed on and you're paying the mortgage. It has to stay in your name personally until it's paid off. Does that make sense?
So if you have, along with that, so if you have the trust for your children,
Yes.
to take care of them, that goes in the same trust, the overall, like, is there an overall trust and then all the things that it does, that it takes care of?
Yeah, so your revocable trust would be the main document. And if you decide that you wanted to have a supplemental benefits trust because you have spendthrift children, you're all going to be very wealthy people and you don't want your children to spend all the money in one place, then you can add a supplemental benefits trust, which would speak specifically to how the children are to receive the assets. But for the most part, a revocable trust is like a catch-all for all of your property, all of your assets. And there can be other trusts that are created separately. For instance, I did a pet trust recently for a woman who, that was her family, her 2 fur babies, and she set it up so that when upon her death, it will be fully funded, and she appointed a trustee, and that trustee will have access to the money to take care of the pets until the pets are no longer alive. There are also retirement trusts, but they are all referred to in your revocable trust as well. So they're referred to, although they are a separate document. They're not. Do you see what I'm saying? They'll refer to your retirement account, and I had someone who had a $3 million retirement account, and they just did not want it to go to somebody that they're going to just spend it crazily. And so that's what they did. They did a retirement fund, a trust. So there are a lot of things involved in estate planning, as you can see. For the basic person, they generally require a revocable trust, and they need powers of attorney, an advanced healthcare incentive, and that usually protects them from all matters of probate, both living and death. But when you have a meeting with your attorney that we provide for you, he's able to look at the membership form that I have filled out and all the information I have taken from you. And then you'll be prepared to question, what else do you think I need? You may not know what you need until you speak to the attorney and he says, well, this would help with this situation. But I have to say 9 times out of 10, the revocable trust and the powers of attorney do the job quite nicely.
Tina, I have a couple people who have questions. So one young lady, Miss Sheila, says she made a comment that you would need the cooperation of the lender to put your property into an irrevocable trust. It varies depending upon your lender. And then a question was, can you discuss Ladybird Trusts, please?
The Ladybird Trust, well, first of all, with the irrevocable trust, right, we have a situation that, if a lender agrees to let you give your property away, then yes, you can put anything you want into an irrevocable trust. I've just not seen it done, quite honestly. But I suppose it could happen. It could happen anytime that you do have a property that has a mortgage on it, but you can put a property with a mortgage in a revocable trust. Does that make sense? That doesn't require a bank permission because you're still the person, you're still the trustee, and you're the individual that owns that property, and you're still paying for your property. So they don't care where you put it, whether it's in a revocable or an irrevocable trust, if it's paid for. So you're right. If you can get a lender to a point, basically say that you can do that, then you can do it. A ladybird deed is we do ladybird deeds. So for instance, a ladybird deed is a deed, it's a enhanced life estate deed, basically. And the document allows the property owner to retain control of their property while alive, and it automatically transfers to a named beneficiary after death. So that's basically how a ladybird deed comes into play. I'm having trouble talking this morning. I think I need more coffee. The owner can sell, rent, or use the property, and they can revoke the deed at any time. So basically, the ladybird deed is put into place because you want a specific person. Maybe your wife, you don't want her to have to deal with any probate issues. You'll have the revocable trust in place, but the ladybird deed automatically would go to her in any event. So you can do that.
Miss Evelyn has a question.
Okay.
We can't hear you, Evelyn. You on mute.
I believe I didn't have really a question, but I mean, I can ask questions when we talk later, but I think the trust was done between me and my dad years before he passed away, because when he passed away, I just filed the papers. And my Social Security, I had a full questionnaire. This woman asked me all these questions. I had some sort of review, and I don't live in the property that we have, our family home. I don't live there, but
Okay.
it is in a Lady Bird trust for my daughter, because I did it in 2022, and I didn't remember when I did this questionnaire back about a year ago, and she told me I would probably have to sell the property, but I'm thinking this paperwork has already been registered and signed off. So they can't make me sell that property.
That's true. So a ladybird deed is not a trust. It's a unique deed that basically will bypass probate just by the way it's written. And what it does, you have created a ladybird deed so that when you pass away, it reverts to your daughter. So
Right.
that means that there's an automatic transfer at your death, and it bypasses probate. It never sees the light of probate. It's not necessarily in a trust, but if
Okay.
you're creating a revocable trust to put all your assets in, all your properties, then instead of retitling your property to a trust funding deed, it would be called a ladybird deed. We would redo the deed to basically say that you are the owner of that property, but it will pass to your daughter by virtue of a ladybird deed. It can be revoked. The deed can be revoked at any time. So, for instance, if something happens to your daughter, or your relationship strained, and you decided that you don't want her family to get it, hopefully that doesn't happen, but you can revoke it and name somebody else as the recipient of the ladybird deed. Also, in some states, the ladybird deed protects you from Medicaid. The Medicaid estate recovery. Most people aren't really concerned about Medicaid estate recovery, because people of wealth, or people who've done the proper estate planning, already has a plan in place for when they do ultimately pass away, what's going to happen. A lot of people have nursing home funds, or they set up accounts to actually deal with your nursing home stay if you're ever going to have it. The ladybird deed doesn't affect taxes or increase the property's taxable value. It's just simply a vehicle to bypass probate and get delivered directly to the person who is to receive the property. Does that make sense to you?
Yes. Yes.
Stacy has her hand up.
Okay.
Yeah. When my husband closed on our house, he was actually the one on the mortgage and not me, but I was put on the deed. What's the difference between that and a ladybird deed?
So you were put on the deed?
Yes.
So there's language in the ladybird deed that has to be there. So if it's just a regular deed, it depends on how it's written. So if it's written as you and your husband own the owners of the property, that's one way. The other way is that if you're not going to create a trust, and all you own a home and that's what you want protected, you don't have enough other assets to go through probate, and that does happen in a lot of situations. I live in Maine, so a lot of people don't have the wealth, especially in the northern parts, and their home is their most valuable assets. So what they can do to avoid a trust is simply have the deed titled Mr. and Mrs. Smith as joint tenants with right of survivorship. So what that means is, when the two people who own the property jointly with right of survivorship, when the first person dies, that property automatically reverts to the second person, because that's how the deed is named. It doesn't go to an estate. It doesn't go to the first person who passed away, their children, or what have you. It goes automatically to the person who is listed as a joint owner with right of survivorship.
And that can be in place even though I'm not on the mortgage.
Exactly. Yeah, you can do that.
Okay,
So I
so
just need to find out what it says in particular, or could it say something that
Well, again, I'm not a lawyer and I can't really give you legal advice, but what I would suggest at that point, you would need to produce the deed so we can have the attorney take a look at it and see what he can do with it. Generally speaking, if the mortgage is in his name only, but the deed lists both you and your husband, then that means, and it's in the registry of deeds now, properly recorded, then you two own it together. And the bank, obviously, when the mortgage happened, they saw the deed because all those documents have to be presented. I assume that the bank doesn't care. They've got one person on the deed, on the mortgage, and they're responsible for payment. It all boils down to responsibility. So the person named on the mortgage is absolutely the guarantor of that mortgage and has to pay it. But you can add a joint tenant with right of survivorship at any time on your deed. The problem with that annotation to your deed is that a lot of people think they can just put their children on their deeds. Oh, I don't need to file a revocable trust or prepare a revocable trust. I'll just put my son on the property. Well, I've seen that fail very badly. The son gets divorced, and guess what happens? Half of your house is in the settlement process of that divorce because your son legally owns half of it, his asset as well, and you could lose control of half of your property. And that's really not what your intention had been at the time. So appointing designations for people to inherit, you have to be very careful. I have a lady right now that's dealing with a son who she bought a property with, and he's locked her out of it. His name is on the deed. She's been paying the mortgage. She can't get into her own home. So there are so many things that could happen that, you just have to anticipate the unlikely events as well as the likely events. So the revocable trust really is a comprehensive plan to put your property into it. So you are still the owner of that property. I would never suggest putting somebody else on your deed other than your spouse, quite honestly.
Tina,
Yeah.
so this is very huge because sometimes we may not be ready financially, but I believe you could do anything with planning. So, can you tell us, people who are interested? We do know that we need to do this because we either have a house or we plan on buying a house. We need to know what to do. Like, what is the membership like? Like, is there a payment plan? What can we expect? Because once we know that, then we can work towards that goal. If you put that on your goal, like that's
right.
my
So
goal.
we do have a program. It's not through Legacy. We have contracted with an individual company, sort of like a credit card. So if you don't have all the cash, generally speaking, so the price of your plan is going to be basically based on your assets, right? And then any additional deeds. And the plan includes, a trust, powers of attorney, an advanced healthcare incentive, and the retitling of one property. So if you decide that you have multiple properties, then we charge extra for each deed. It depends on where it is, but it's generally $100 extra gets added to your plan. Likewise, if you have corporations and LLC, it's going to increase the price of your plan because those are extra things to fund those into your trust. So we basically have a two-tiered plan. If your assets are $1 million and under, the base price is $2,895, $2,895. That price is paid in two payments, half when you sign the membership agreement. After you sign the membership agreement, you're appointed a coordinator, and they will put you in touch with the attorney in the state that is on our approved attorney list. That price of the attorney appointment is included in that $2,895. So once the attorney meets with you, you have 3 days after that meeting to cancel your membership and get a full refund of your half deposit. You choose to go forward, then the attorney will proceed to prepare your documents. Usually takes about 6 weeks. Sometimes it can be longer. It just depends on trying to get the client and the attorney together. Scheduling conflicts can make it a little bit longer, but we try to use Zoom so it can happen quickly. Once that happens, your Zoom appointment, then you have 3 days go by, then you continue. And at the end, when your documents are delivered to you in your home, a notary will notarize them in your home. And then at that time, they'll collect the other half of the payment. So a lot of people don't have that money all up front, which is understandable. So we have a situation called Law Pay. So most of the members that I've worked with have used a credit card because they have basically an 8-week window to pay the card in full, and they get benefits and points. But if you don't have a credit card that you want to use, there is a process called Law Pay, where you prepare the application and submit it to. We submit it to Law Pay. They will pay for your trust. It does incur an additional cost. I think they pay a one-time. You have to pay. They add it to your bill. I think it's $300 or $400 for basically lending you that money. So it does add more money to the preparation of your estate, but it does allow you to make payments monthly. Does that answer your question, Lakeisha?
Yes, because a lot of times I feel like, I like to know the cost of things ahead of time. So that way I know I can work towards that goal. Okay, this is how much it is. So I need to put this amount aside or whatever it is that I need to
No,
do
that's a good
to
spot.
complete it. Once I know the numbers, like once you know the numbers, you can kind of, work things out. You just never know
Right.
what life can grant you where you might all of a sudden now you have the money, but at least that's one part of it that you don't have to worry about because you already know, okay, this is like if you don't have plans for your money, somebody else will have plans for your money.
They absolutely do.
I
You're
like
correct.
to actually know, know the money, know the figures, and I can work towards that goal. Because this is something that's very, very important, something that's very, vital. A lot of us are business owners. We're stepping out of our comfort zone. Our business is enhancing, more than what we realize. And so we need to know what to do with the money. Like we need to know when we get this
Exactly.
money exactly what to do with it.
That's a very important point. And I said to you, there's 2 levels of cost. It's either your estate is worth $1 million and under, or your estate is worth $1 million and over. If it's worth $1 million and the base price is 33, it jumps a bit, 33.95. So it's because there's more, we generally assume that there are more things that you need to, I don't know why they do that, quite honestly. I'm going to be honest with you. I'm not sure why there's a 2-tiered plan, but it doesn't increase when your assets increase. So it's what your assets are worth at the time. And that's why a one-to-one presentation and an appointment is important, because when you're done, the presentation that I give, I just gave you little bits and pieces. There's so much more to Legacy Assurance Plan. We have a benefits of Legacy Assurance Plan, which I'll show you. It's 17 items that provide you with all of these different benefits. And I can provide that to anybody. I can send it to you via text in a PDF or email. You just need to send me, I can give you my telephone number. You can text me your email address at 207-415-0826. I can also send you PDFs of revocable trusts, funding a revocable trust, the difference between an irrevocable trust and a revocable trust, and what might be best for you. So what I've given you basically are teasers, I guess you could say, because it requires more time than a short presentation, because every client is unique. You have different properties, you have different situations. There are blended families, there are same-sex marriages, there are people who cohabitate together and are not married. There's just so many different things that could be different from your estate plan to somebody else's. So trying to answer generalized questions is a bit difficult, and it's easier to talk to the person and address their individual concerns and their situation. And I am
I do apologize. Tina,
No.
some people would like for you, if you can, put your information in the chat, because there's, yeah,
Okay, I can do
information in
that.
the chat. Also, there was a young lady, Miss Sandra Mack. Are you still here, Sandra? You had some information that you want to talk about that people should go to. Are you still here, Sandra?
I don't see her on
Oh, she's not. Okay. All right. So it's 10:01, but I did want to share about one grant. Like I be having these grants and I never really get a chance to talk about the grants. So I don't know. I think I'm gonna start giving out the grants at the beginning of the show. So I'm just gonna only talk about one. I did put it in the chat. It's a very short grant. I'm gonna complete it today. It's called the Honeycomb grant. If y'all, I don't know if you all heard about it, but it's very short. It's in the chat, the honeycombcredit.com chat breakthrough. So I went through it. It's a very short grant. A lot of us on here will qualify for that particular grant. And what I'm going to start doing too on my Instagram and on my Facebook page, I'm going to start posting a lot of grants and a lot of different events on there. So if you haven't followed Ask Madam Finance, please do, because after going to the Kevin Harrington event, I'm truly going to step up my game as far as giving us valuable information to help us and our family and our friends. Any questions? It's 10:03. I want to say thank you so much. Welcome, Marshall and Connie and everyone else. I really appreciate you taking out the time, but I just thought this information is just so valuable and so needed, in our community. So with that being said, thank you, Tina. We're going to have you on again because, like you said, this is a lot of information and, giving it out, dissecting it a little bit at a time will help us to get a better understanding so that we can not only help ourselves, but be able to also help others. So, I hope you'll be open to that.
I am.
This month was amazing about wills and trusts and giving us different outlooks on it. So with that being said, everyone, let's give ourselves a hug, because sometimes we forget to be a little bit more compassionate with ourselves, to be more loving with ourselves. Let's hug the world, because the world needs a hug too. And let's sprinkle peace, love, and happiness towards those that are in authority. You never know. Enough people sending enough love and light to the president and those that's in authority, we may be surprised of the outcome.
The other thing I might mention to you, Lakeisha, if there are specific things that people are interested, maybe give you the heads up and I can be better prepared. I was prepared basically for doing just the presentation alone, answering a few questions, but you can see that people have multiple questions. I didn't even touch on Medicaid asset protection. And that is one of the things that I can talk about next time, and how the irrevocable trust deals with that. So you're right, there is an awful lot of information, and that's why a one-to-one appointment is pretty important.
All right.
And I also want to invite you all on Friday. We're going to hear from Aaron Lyons, who's going to explain that we are now in it's going to explain the fifth dimension and the shift that we are now in. And it's amazing what she shares, that the planet has already shifted. We are in it, and what we need to do as a result of it. It's good. It's delicious. That's Friday. We will start right at 9, so be on time. Set your clock.
Is it the link to sign it? It's
the same, the same space, the
so
same
Friday at 9 a.m.
Zoom.
Okay, that sounds good.
Yeah.
Thank you.
All right. Peace out.
All right.
Love you.
Have a wonderful and fantastic day on purpose. because it's always
I see.
You too.